The following podcast is taken from a live broadcast on Inspire FM.
Assalamu alaikum. Welcome everybody to the first ever Ask Your Lawyer show of 2020. I am your host, Attiq Malik, Director of Liberty Law Solicitors, and I'm here today kicking off the new year with a Toolkit show. It's a one-on-one show, live show, where you can call in and ask me questions directly on any area of law that we are discussing. And if it's something that we're not discussing and it's something that I can answer, I'll try my best. But otherwise, the topic of law that we're discussing for today, you can call in one-on-one, ask me any question or any comments that you might have. End of the day, this is your show. It's all about tailoring it to you, owning it, and asking questions or comments or making comments which you feel that it should be heard. Sometimes you might feel that a question is a silly question, but there might be other people out there with the same queries as you, and by asking the right question you could be not just helping yourself but helping others too. We are today going to be discussing legal changes that are coming up in 2020, in particular changes in employment law, because in employment law there is a annual change that happens every 6th of April of each year. So every 6th of April of each year, and sometimes October as well of each year, but in particular every 6th of April each year, you will find that there's new legislative changes happening in employment law year in, year out. And it's always good to know in advance before these changes happen what they are, because they can affect either you as an employer in terms of how you run your business, or as an employee, because it's important to know what your rights are. Okay, now how do you get involved in this show? You call in 01582 481822. That's 01582 481822. You can also WhatsApp on 07779 481822. That's 07779 481822. You can email in on info@inspirefm.org. You can also watch us live on Facebook Live with the tag Inspire FM Luton. So if you search for Inspire FM Luton on Facebook, you can watch the show live. We have cameras set up, HD cameras, may I add, where you can see everybody within the studio clearly in HD. Now, as far as the show is concerned going forward, we obviously wish to make the show as interesting and as engaging as possible. And one way to do that is not only to mix it up with toolkit shows such as this, and then to have panel discussions, but also to take feedback from you, the listener. There may be topics or shows that you feel important that we haven't covered. If that's the case, please feel free to contact the studio or myself directly at Liberty Law Solicitors and let us know what you feel is an interesting topic that needs to be covered, that we should cover. And we'll do our best to do that. We do have access on the Ask Your Lawyer show to some of the creme de la creme lawyers in terms of both solicitors, barristers and QCs across the country in multiple areas of law, and therefore are able to bring them on live to discuss a particular topic. Equally, there may be other lawyers out there who feel that they can make an important contribution. If so, please contact us. More than happy to have you on as well. Be part of the conversation. Okay? So let's do this then. What is happening in 2020? So in employment law, let's start off with that and let's see how we get on with time, because often we are really ambitious when we start and we aim to cover many topics, but in the end time really does fly, and before you know it we're at the end of the show. So let's see how far we get, and I'm going to break it down as much as possible to assist listeners who may not be familiar with employment law as to precisely what it is that we are discussing. But we have got 5 major changes that are coming up in employment law this year. As I said earlier, they will be taking effect from the 6th of April of 2020. Now, these changes, there may be others that could happen because at the moment, as you know, we are right in the middle of a whole Brexit mess. And if Brexit happens, you never know what the future government or the current government even may do within a few months of this new year. But currently, we have got 5 important changes coming up. So, first of all, there is a new right to a written statement of terms. Should come. Okay, apologies for that. Yeah, new right for a written statement of terms. So some of you may ask, what is a statement of terms and what is the new right? Now, the new right well, let's examine the current right first of all. Currently, the position is this. All employees who have been continuously employed for more than 1 month are currently entitled to a written statement of terms, and that statement of terms has to be provided within 2 months of them starting their employment. So what is a statement of terms? A statement of terms is what we, as in the average person, often refer to as a contract of employment. So under the Employment Rights Act, it sets out what the bare basics are for a contract of employment to be a contract of employment. So that is defined by the reference of written statement of terms. And in the Employment Rights Act, it clearly says that you need to specify what a person's job role is, their start date, their salary, and the basic contractual entitlements such as holiday pay, notice pay, etc. So these basic sets of terms have to be set out to amount to a contract of employment. And what that means is that to satisfy the Employment Rights Act, you don't actually have to have a contract of employment per se. If you have a document that satisfies the requirement of statement of terms, or written statement of terms even, then the employer, the business, has satisfied their legal requirement with regard to what is the statutory minimum that employer is required to provide to an employee when it comes to a contract of employment. And why that means that you don't need a contract of employment per se is because if a business was to give to their employees a letter or an email, for example, which basically said, "Dear Mr. Smith or Mr. Khan, these are your statement of terms that we are engaging you under," and then bullet point 1, 2, 3, 4, 5, 6, and each bullet point sets out one aspect of the minimum requirement of statement of terms, such as their start date, their job role, their salary, their holiday entitlement, their notice entitlement, etc. So if a business does that, then they've satisfied the basic entitlement to a written statement of terms. And what that then means is if the employee believes that there is no contract of employment because they were never given a formal contract to sign, that is potentially incorrect because that email or letter amounts to the basic written statement of terms. Similarly, following on from that, if an employee believes that a contract of employment is only in existence when they sign a document that says contract of employment, that is also incorrect. As employment lawyers, we often get this situation where people will contact us and say, "I haven't been given a contract of employment," or "I was given a contract but I never signed it, so am I still bound by the clauses in there?" And the reason why this question often arises is where a person is working for a company and following termination, they wish to work for another company which might be a competitor to the first company. And to stop that from happening, the contract of employment contains what's known as restrictive covenants, which take effect after termination of employment and stop an employee or ex-employee working for a competitor, for example. Now, so, as I said, you may get a situation where an employee has not signed their contract of employment, either deliberately or just an oversight. And so they will raise the question, "Well, I've never actually signed this agreement, so is that clause still binding on me?" the fact is that that clause is binding on you, even if you haven't signed the contract, because at the start of the employer-employee relationship, it was made clear that these were the terms upon which this relationship was established. And so, even if you do not sign the agreement, by the performance of your work on a day-to-day basis, in accordance with the terms of that contract of employment, the employee has affirmed, which in other words means agreed the terms of the contract, and therefore that contract is legally binding. Going back to the statutory requirement then, the reason why that's important to understand is why there is no, the statutory minimum does not require a contract to be given, but actually a written statement of terms. And the reason why it's important to understand that difference is because what that also backs up the position that I've just set out, that if a contract is given, even if it's not signed, it's still legally binding. All an employer is supposed to do is to highlight the main headline points in terms of a role that the employee must applies to the employee, and that satisfies a legal requirement of providing a written statement of terms. So some of you may ask, well, why is it then that when I start employment with a company, they provide me with a very substantive contract of employment? In some cases, you will see contracts of employment which might be 15 or 20 pages long, if not more, or even if they are shorter, in a lot of these cases, they will refer to another document known as the staff handbook or workplace manual, which contains further policies and procedures, such as disciplinary procedure, maternity leave procedure, sick leave procedure, etc. And so an employee or a person may ask, well, if that's a statutory minimum, simply setting out your job role, salary, holiday, notice, pay entitlement, etc., just in brief points, why is it that quite often that we are required to sign a detailed contract of employment? The reason for that is this: contracts of employment are not a legal requirement aside from the provision of a basic written statement of terms, but it is best practice for a business. Contracts of employment are drafted for the business, so by the business, for the benefit of the business, to protect it, and is there to give clarity to the employer-employee relationship, so that it's clear to the employee exactly what they are signing up to in terms of job role and salary, but also other matters such as the procedures that the employer has, their requirements from a job perspective of what they expect from the employee, and what various procedures exist during the course of employment in terms of disciplinary, grievance, sick leave, maternity leave, disability, reasonable adjustment requests, health and safety at work, etc. And that is there as best practice by an employer to protect the business, so that there's clarity as to what the procedures in place are, what the business relationship is between employer and employee. And so it's not necessarily, it's not a legal requirement, but it's there to protect the business. And similarly, you also have restrictive covenants in place in contracts of employment, because the legal starting position is, if someone has left employment and is looking for another job, they are free to work for whoever they want, wherever they want. That's a legal starting position, unless that employee has agreed in writing, is a contract with their previous employer, that the following termination of the employment, there are certain things they agreed not to do. Now, even that has a limit, because the starting point is that there are no limitations on where and who you can work for once you leave employment with somebody. And so if there is a restrictive covenant in place that stops someone from exercising their legal right of work, then that has to be limited in extent. Limited in terms of time frame, limited in terms of geographical location, and overall reasonableness applies. And reasonableness is a test that applies to all contractual terms. So whilst a person can write whatever terms they want in a contract, such as a contract of employment, and an employer might have a stronger position because they can say to a prospective employee, well, if you want to work for us and get paid, you've got to sign this agreement. There's no negotiating on that. So whilst that might be the case, even then, if there is what they say a breach of contract, that breach of contract is only actionable and has force if a court of law deems that contract to be enforceable. And it's only enforceable if it's reasonable. If a court of law deems a contractual term to be unreasonable, then neither party can rely on that to enforce against the other. So even there, there are limitations to what can be put in place in a contract of employment on the law of reasonableness. So that's how it currently works. The new law, which is coming into place from April the 6th, 2020, states that all new employees and workers will have the right to a statement of written particulars from the first day of employment. And there's additional information will have to be included as part of this extended right. Okay? Now, what does that mean then? That means, first of all, that we have moved from a position of employees being required to have or having the legal right to a written statement of particulars. We have moved from that to also including workers. And that's quite important. What is a worker and what is an employee? This is often a question that baffles many people. It's a very blurred line, to be honest with you, between employee and worker. In summary, anybody who's not an employee but is employed directly by the company and does not fall into the category of self-employed can be regarded as a worker. An example of a worker could include agency workers who also have their own rules and under the agency worker regulations, they have their own entitlements now. But we often see situations where a person brings a challenge against an employer, but their rights are limited because they're not actually an employee. They actually fall into the category of a worker. That in itself is a huge topic to explain. And we've done shows in the past on that. So if you were to go into the podcast for Inspire FM, you will find a previous podcast from us where we have examined in detail with different statuses that exist in employment law, that is of an independent, self-employed person, a contractor, a worker, and an employee. So what we are seeing here is an extension of protection really being given to workers which they've never had before, that they are also now entitled to a written statement of particulars, which I have to say personally is quite surprising, because in the past the Tory government has always been renowned for limiting workers' rights and being more pro-business. So there's been more of a bias towards businesses. However, we are seeing here something slightly different, because the right to written particulars, so effectively the right to a contract, is now being extended to workers too. And the other major change here, which applies to both the contract of employment for employees and the contracts for workers, is that it has to be given, the entitlement exists from the very first day of employment. So the difference between that and the coming position and the current position is that at the moment you're only entitled to a written statement of terms if you've been employed for at least a month or more than a month. So if you were employed somewhere for a couple of weeks and then you were dismissed, you are not entitled to a written statement of terms currently. Come 6th of April 2020, even if you've been engaged as a worker or employed as an employee by a company for 1 day, irrespective of whether you were dismissed within a week or 2 weeks, you are still entitled to a written statement of terms. Now, some of you might say, well, what's the big deal? So what? What happens if this person doesn't get their they don't get their written statement of terms? Well, what happens is that you then breach employment law and the legal right to a written statement of terms, and that can have one or a number of different consequences. One consequence that can have is the employee can then bring a claim for compensation in light of that failure. So again, that incurs expense for an employer in terms of having to defend such a claim, as well as paying out the compensation, as well as a legal order by a tribunal that a written statement of terms should be made, and in what terms. So again, all of that is undesired by any employer. Secondly, let's follow this through. Employer on day one or worker on day one is entitled to a written statement of terms. They don't receive it. The employee makes noise about this and says to the employer, listen, you're supposed to give me my written statement of terms, you haven't. The employer refuses to comply. A week later, 2 weeks later, after continuously asking for it, the employee is sacked. Now, that is quite huge if that chain of events can be proven and shown. And I will explain why and how that is important and how that changes things in the second part of the show, as we are now currently, unfortunately, come to the end of the first part of the show. So listeners, please stay tuned, and I'll see you on the other side to explain how this is an important change too. Assalamu alaikum. See you soon.
You're listening to an Inspire FM podcast, making available our popular programs from our daily broadcast on Inspire FM.
Assalamu alaikum. Welcome back to the Ask Your Lawyer show. This is the second half. With me, your host, Attiq Malik, Director of Liberty Law Solicitors, and we are doing a Toolkit show today. That's a one-on-one show with myself, discussing a topic of law. Today we are discussing updates, legal updates for 2020, in particular for employment law. And the reason for that is employment law, as I said in the first half of the show, has an annual cycle where every 6th of April there is new legislation coming into play, and it's very important because it affects all of us. Either many of us are business owners that employ people, or we are workers working for somebody, or a bit of both. And employment law encompasses both of those relationships and others, including consultants and third parties, contractors who work for people. All of us are out there earning a living. Employment law touches all of our lives, whereas cases like criminal law only touch us because someone might have done something wrong criminally. Family law may only touch you, something's gone wrong in the family. Employment law is present in everyone's lives every day because most of us are having to work for a living, and it affects us. And so it's very, very important that we understand what our employment rights are to ensure that we are protected, and if there is a breach of that we action that straight away without hesitation. We should never be afraid of protecting our legal rights. And I'll give you an example of why, leading on from the end of the first part of the show. So the first part of the show, I explained in detail what a written statement of terms was. And just to recap, a written statement of terms is the equivalent of what is known commonly as a contract of employment. And I set out what the legal minimum requirement for that is in law, which is quite different to the common understanding of what a contract of employment is. And in addition to that, I explained that there was a change coming in from the 6th of April of this year, 2020, where all new employees and workers now will have the right to a written statement of terms. And I explained how that's different to the previous position. But in particular, what I also explained is why this is important in terms of being observed for employees and employers. And in the first part of the show, I explained that one issue is that if you fail to provide a written statement of particulars, then that employee or worker potentially has a claim against the company, which they can action in an employment tribunal and bring a claim. And whenever a business faces a claim, it's expensive, it's costly from two fronts. One is the defending of the claim itself. So simply having to put time and effort into defending a claim, is time and effort which could have been better spent making money for the business. And on top of that, engaging lawyers to represent you, that is also very expensive. And in addition to that, the sanction ultimately if an employer loses, which is quite likely if it's very straightforward and they're supposed to give a written statement of terms and they haven't, if that was to happen, then they would have to pay compensation as well. Now, that so effectively the new change gives employees and workers a new mechanism for claiming compensation from an employer if an employer fails to observe the legal requirements of a written statement of terms. Now, as I said, the written statement of terms has to be provided now to employees and workers, which previously was only applicable to employees, and now is also applicable from the first day of employment, whereas previously you were only entitled to it if you had worked for somebody as an employee for more than 1 month. So the situation now is that if from the first day you start working for someone, you then have the legal right to be given a statement of terms. So the reason why this is all important also is in the second example that I'm about to give. And this is important because it also helps explain why it's important to know your legal rights and why you should not be afraid of challenging or bringing to the attention of an employer a situation where your legal rights are not being observed. And in this case, we're talking about a very basic legal right. That's the legal right to basic statement of terms. A statement, a document, a letter, an email even, just setting out what your job role is, what your start date is, what your salary is, your notice pay entitlement, your holiday pay entitlement, just very basic terms. Now, this is the example that I'm giving. An employee realizes that he should have been given a written statement of terms that entitlement stems from the very first day they've started working. And then they are asking the employer for the written statement of terms. The employer's maybe, let's say, being a bit lazy, hasn't got around to it. The employee is getting quite agitated, as some people sometimes do. Not just because of there's a time limit to it and there's been a breach of that, but quite simply because they feel it's an entitlement that they should be honoured promptly. A lot of people will get upset if something that they're entitled to is not given to them straight away. It's irrelevant sometimes that the legal requirements should be provided within 2 months. Yes, that might be the case, but it doesn't stop someone from becoming upset that they haven't received their contract. Sometimes people just feel reassured that they've got something in writing confirming that they have indeed got the job that they wanted. They are going to be paid the right salary, and they are fully aware of their minimum basic legal employment entitlements with the employer. That peace of mind is also very important. And the reason why that's important is because of this example I'm about to give. Employee says to employer, "Where's my written statement of terms?" Employer says, "Okay, yeah, I'll get back to you." A week passes by, nothing's happened. The employee becomes a bit more agitated, starts asking again. Employer, either deliberately because they're getting annoyed or just because of administrative issues, there's a delay, they don't get back to the employee. Another week or so goes by, that the employee starts, getting a bit more agitated and says to the employer, "Well, look, what are you playing at? Why are you not giving me my written statement of terms?" Immediately, the employer thinks, "You know what? I'm not having this. I'm going to sack this person and get rid of them." Now, why would the employer do that, first of all? Why would the employer think that that they can just get rid of someone just like that for no reason? The reason is this. In employment law, if you are dismissed for a bad reason or no reason, generally speaking, the claim that you would bring would be that of ordinary unfair dismissal. Okay? So you're saying I've been dismissed unfairly, and therefore the claim is an unfair dismissal claim. However, to bring an unfair dismissal claim, you have to have worked for the employer for a minimum period of 2 years. So what that means is if you've worked somewhere for a week, a month, 6 months, or even a year, you have not worked for 2 years, so you've worked for less than 2 years, and your employer sacks you for a reason which is a rubbish reason, or no reason, and just says, get rid of you, the starting position is that you are unable to bring a claim for unfair dismissal. Now, a lot of employers know this. And so in the current example I've given, the employer may have thought, well, do you know what? This employee is getting a bit annoying now. I don't know what his problem is or her problem is. I've told them I'm going to give them a written statement of terms. I haven't refused. I've got plenty of time to give it. And they're doing my head in. And do I really want this person working for me? You know what? They can't even do me for unfair dismissal. They haven't been here for 2 years. Let me get rid of them. And they sack them. Okay? So that's how sort of the mindset would work generally. However, you have to also be aware that within this rule of the 2-year service requirement to bring claim for unfair dismissal, there are exceptions to this. So there are certain scenarios where if a person is dismissed for failing to, if a person is dismissed and they have less than 2 years service, in certain scenarios they can still either A, bring a claim for unfair dismissal, or they can bring a different claim but get the compensation that they would normally get for unfair dismissal. That is the compensation for loss of earnings. How would you do that? Well, if you are dismissed because of your race, religion, sex, sexual orientation, age, disability, etc., so a breach of the Employment Rights Act, then in that situation, that dismissal amounts to an act of discrimination. And for discrimination, there is no minimum service requirement. Okay? And therefore, employer has to be very careful that the termination of employment, it cannot be interpreted as an act of discrimination. Similarly, another example would be, for example, TUPE. TUPE is an acronym for the Transfer of Undertaking the Protection of Employment's Employees Regulations. And TUPE exists where, for example, one company is getting rid of a contract to another company or selling parts of a company to another company. And in that situation, the employee's employment is being transferred from company A to company B. Sometimes what company A or company B will do to increase the value of the transfer of work by reducing overheads is to get rid of an employee either before the TUPE transfer is due to take place or immediately after as a redundancy. If it can be shown that the real reason for this redundancy or termination was linked to the TUPE transfer, then that's an exception which allows the employee to bring a claim for unfair dismissal. Now, moving on to the example that I've given, there is another route for exception, and that is where employee is dismissed for asserting a statutory right. So what is a statutory right? A statutory right is where, in law, a person has a legal right to something. So where there is a statute, a piece of law, a legislation somewhere, which gives an employee a certain right for something. So in this case, you have got the Employment Rights Act, which clearly gives a legal right to a statement of terms to an employee. So where that has not been provided and the employee asserts that right, so he's raised that issue with the employer and said, I am entitled to this legally, and that right that's being asserted is a statutory right because it's written in law. And then because of the assertion of that statutory right, the person is dismissed. They are then able to bring a claim for unfair dismissal. So it's quite huge actually, because whereas before they could not assert that statutory right unless they've been employed for a month. The statutory right now exists from the first day of employment. And so if an employer is faced with a request for such, they need to consider their position very carefully and act carefully. And because if they just get annoyed and from a knee-jerk reaction just decide to get rid of this employee who's asking for employment terms, written statement of terms, and then suddenly they're facing the sack, you are opening the door to an unfair dismissal claim on the basis that they have asserted a statutory right, which is why they were dismissed, which then circumvents the normal protection an employer has from employees who wish to bring unfair dismissal claims, namely the 2-year service requirement. So hopefully that explains in a nutshell. That's the first change. And believe it or not, there are 5 changes coming in April 2020, 6th of April, and I've just spent almost 45 minutes explaining the first one. But I'd rather do that, take time doing it, because it is quite complex and hard to explain. So what I would now do is go through the rest of the changes, but I'll try not to spend too much time on each one, because then we will quite frankly run out of time of some important updates. The next update is the agency worker rules. Now, the agency worker rules are set out by the Agency Worker Regulations 2010. These entitle agency workers to receive the same pay and basic working conditions as direct recruits once they've completed 12 weeks continuous service working in the same role. This is known as the Swedish derogation. Well, the Swedish derogation is another term. And what the Swedish derogation does, it provides an exemption to the right to equal pay if the agency workers are employed under a permanent contract of employment with a temporary work agency and are paid by the agency for periods between assignments. So this is known as a Swedish derogation. So ordinarily the position is, if an agency worker is working for a company, for let's say any big company, I don't know, Waitrose for example, for 12 weeks continuously, and let's say they're on the shop floor working, I don't know what the roles are in the supermarkets, but I don't know, a checkout sales assistant role, and so they are entitled to receive, at least if they've been there for 12 weeks or more continuously, they should be on the same pay as permanent workers that are there. That's what the agency worker regulations do. They provide protection for agency workers so that they're not exploited by virtue of their weaker bargaining position, because they are not employees and do not have the full employee employment rights that protect them from employer treating them badly. Now, the Swedish derogation is an exemption to that what that means is it's an exemption to the equal pay if the agency worker is employed under a permanent contract employment with the temporary working agency. So what that means is you've got an agency which is placing the worker with, say, Waitrose again, for example, but in doing that, there's a contract of employment in place between the agency worker and the agency that's placing them, and where there is a gap between assignments. So, for example, someone is working at Waitrose, say, for 12 weeks, and then there's a break of 2-3 weeks, and then they're starting work at another supermarket for another few weeks. The gaps in between those two assignments, if they're being paid for that as well, not just for the hours they work by the agency, and they've got a contract of employment with the agency, then they are not entitled to be paid the same as permanent workers, even if they've worked 12 weeks or more. And that process is known as a Swedish derogation. The new law will be, from the 6th of April, that there is no such thing anymore as Swedish derogation. The position will be much more simpler, that once the agency worker has satisfied the 12-week qualifying period, they'll be entitled to equal pay to workers who were engaged directly by the worker. Simple, job done. Again, we are now seeing another extension of protection for workers' rights here, because the previous right had an exception to it, which is now being taken away. So it doesn't matter now whether you've got a contract of employment with your agency or not, or whether they're paying you for period in between assignments. If you've working for an agency, for a company for 12 weeks or more, then your basic salary should be the same as the permanent employees that already work there. The other change is, on or prior to the 30th of April 2020, agency workers whose existing contracts contain a Swedish derogation provision must be provided with a written notification by the agency that it will no longer have effect. Now that's similar to the previous example that I gave. So if worker is not given that written notification, there's potentially two issues arising out of that. One issue is because the employer hasn't realised and therefore has not increased their salary in line with the permanent workers, and therefore that would allow the agency worker to bring a claim under the agency worker regulations for unlawful deduction from pay, effectively, and breach of the equal pay requirements. But also, if a written notification hasn't been given, even if their salary has been increased, because that's another failure, there is compensation that can be, and a sanction that can be imposed by a tribunal for that as well. In addition to that, on the 6th of April 2020, all agency workers must be provided with a key fact statement setting out the terms under which they will undertake work, similar to written terms requirement as we already set out, as being rolled out. Very interesting, because what that means then is proactive steps are being taken here to improve the protection for agency workers, because they are vulnerable, aren't they? Agency workers not directly employed by a company will always be regarded by a company as easily disposable and cheap labour sometimes. And the aim of this legislation is to rectify and rebalance that. Now we're running out of time. We've only got about 6 minutes left, so I'm going to go through the next few changes. IR35 changes coming in. What is IR35? IR35 applies to it's tax law, basically. Tax rules apply to an individual, a worker, who performs services for another. Now, the reason why this is important is because people will often invoice companies and work for them as a contractor and get the benefit of self-employed tax rules under the IR35 rules. This is all changing now. They're going to make it more stringent. And from 6th of April 2020, there will be IR35 rules being implemented for medium and large businesses in the private sector, which will mirror the changes that took place in the public sector in 2017. So under the new regime, for all contracts entered into or payments made on or after the 6th of April 2020, the owners will shift from the personal service company, which is also known as a PSC, to the end user client to make a status determination. So, whereas currently, if I'm contracting and I've got a limited company set up and I'm invoicing the company that I'm working for, I will say that I fall within the IR35 rules or not to get the benefit of a self-employed or limited company tax setup. Now it's for the end user to make that assessment and confirm that. And the responsibility for accounting for tax and national insurance will shift to the party who pays for the individual services, known as the fee payer. So what that means then is if someone is paid as self-employed when they should not have, then it's the business that is now going to be liable as opposed to that person who was submitting the invoice. And in anticipation of these changes, it's essential that the medium and large businesses carry out an assessment to determine whether the new rules under IR35 will apply to the independent contractors and review their contracts and pay arrangements accordingly. So that is best practice, that's not law. So in preparation for all of this, it is advised that medium and large businesses do assess their position with all of their contractors to make sure they're not going to get caught out by any of these new tax changes. Important point to note, and it is important because people don't seem to know this, small businesses are not affected. The new IR35 changes do not affect small businesses, only medium to large size businesses. So if your business falls under the category of a small business, quite frankly, don't worry about it. Done. Okay, next one. Holiday pay reference period adjustment. Current law, the calculation for holiday pay is done where people have different hours that they're being worked. Currently, the reference period is 12 weeks. So what you do is, if you want to work out what someone's holiday pay entitlement is, you look at their past 12 weeks' pay and average it out, and that is what the holiday pay entitlement is during the holiday. The new law is that would increase from 12 weeks to 52 weeks. And that's, again, increasing the protection, because in some cases, a person may not have worked many hours in the 12 weeks prior to the holiday pay being a holiday request being put in, whereas in the previous 3 months, they might have done really well. So now the average, the reference period is no longer 12 weeks. From the 6th of April 2020 onwards, it's going to be looking at the full 52 weeks, which I personally think is a good thing, and is, again, another extension of employees' rights and protection. And in doing that, you discard any weeks where the employee has not worked or where no pay was received. Again, protecting the employee so that you are not disadvantaged by the fact that you were off sick for a certain period or not working for whatever other reason for a certain period. In those 52 weeks average, you only look at the worked weeks. So what weeks they were worked and paid for, and what the average pay was over a 52-week period. And that average pay is what the pay is entitled to for holiday pay. Very, very important. Okay, and this again helps people who might do seasonal roles for companies, etc. Currently, we have now coming in from 6th of April 2020, potentially, but still think waiting confirmation. But my understanding is coming in is the new parental bereavement law. Currently, there is no current law for parental bereavement. Under the new law, which is going to be spearheaded by the Parental Bereavement Leave and Pay Act 2018, it will allow bereaved parents the right to 2 weeks of leave following the loss of a child under the age of 18 or stillbirth after 24 weeks of pregnancy. So currently there is no such a legal right. Once this law comes into place, and if you are unfortunate enough to lose a child who's under the age of 18 or suffer a stillbirth after 24 weeks of pregnancy, you will be entitled to parental bereavement leave and pay. So you'll be allowed time off, pay time off, which does not affect or come out of your holiday pay or your sickness pay or affect you negatively in any way. And I think this is very good. Again, another extension of employment rights. And the bereaved parents will be entitled to take their leave in a 1 2-week block or in 2 separate blocks of 1 week. The leave must be taken before the end of a period of at least 56 days, beginning with the date of the child's death. And bereaved parents employed with a minimum of 26 weeks continuous service will also be entitled to receive statutory parental bereavement pay. And those with less than 26 weeks continuous service will be entitled to 2 weeks of unpaid leave. Apologies, I would love to go into more detail about this. I think it's a massive thing, it's absolutely huge, but we've come to the end of the show, so please pray for me. Assalamu alaikum everybody, and we'll look forward to tuning in on the next show. Assalamu alaikum.
Thank you for listening to our podcast. We stream our daily broadcast on inspirefm.org. You'll find all our daily updates on our social media at Inspire FM Luton.